Introduction. Shayara Bano versus Union of India, better known as the triple talaq case, gave India a historical judgment that declared the practice of triple talaq to be unconstitutional. The triple talaq judgment is widely regarded throughout the jurisdictions as a safeguard against social evils because of the astute and justified reasoning provided by the majority bench of the Supreme Court. India finally abolished the regressive and immoral practice of instantaneous triple talaq. This case is confined to the topic called triple talaq. Shayara Bano's case led to the ban of the Muslim practice of triple talaq. It is a process of divorce under the Sharia law, where a Muslim man can instantly divorce his wife by pronouncing the word talaq 3 times without any state intervention. The means of communication might be in any form, written, oral, or maybe electronic, which further enhanced a Muslim woman's vulnerability during this sort of unilateral and arbitrary divorce. Talaq is the Arabic word for divorce. There are 3 types of divorce under Sharia law, from which only talaq-e-biddat is irrevocable. It is mainly prevalent among India's Muslim communities that follow the Hanafi school of law. Under this law, Muslim women can't divorce their husbands, whereas husbands can. Women need to move a court proceeding for divorce under the Shayara Bano had been married to Rizwan Ahmed. In 2016, through oral triple talaq, talaq-e-biddat, Rizwan divorced her. A writ petition was then filed by her in the apex court saying, as a violation of Articles 14, 15, 21, and 25 of the Constitution, the performance of the practices of talaq-e-biddat, polygamy, nikah halala, should be held unconstitutional. What is triple talaq? Triple talaq means a practice whereby uttering the word called talaq thrice times the Muslim man can get divorced. With the advancement of technology, this concept was misused, where husbands send talaq through even voice notes, WhatsApp messages, and all. Here the means of communication could be in any form, i.e., written, oral, or even electronic, which further enhances a woman's vulnerability in this arbitrary and unilateral divorce. This controversial custom, given that it is an intersection between gender identity and community, has unsurprisingly left Muslim women prone to abuse and in a morbid state, especially given the socio-economic aspect where most of the women are financially dependent on their spouse, and the added fear of this whimsical divorce leaves many cases of marital abuse unreported. Description of Shayara Bano vs. Union of India. Instantaneous triple talaq is held unconstitutional by the Constitutional Bench. The apex court has held the practice of triple talaq, talaq-e-biddat, unconstitutional by a 3.2 majority. And recently, that is on 30th of July 2019, the Parliament of India passed the Muslim Women Protection of Rights on Marriage Bill 2019, which declared the practice of triple talaq as illegal and unconstitutional, and also made it a punishable act. From 1st August 2019, the courts have finally brought justice to those women who have been a victim of triple talaq. The court has ensured that the ideas of equality, especially gender equality, are not mere theoretical ideologies. Background of Shayara Bano versus Union of India. A woman survivor of the grounds like domestic violence and dowry harassment was divorced by her husband through instantaneous triple talaq. She then filed the petition before the apex court stating that this instantaneous triple talaq, polygamy, and nikah halala in the personal law of Muslims are violating Art 14, Art 15, Art 21, and Art 25 of the Constitution. It was supported and criticized by many organizations. After that, instantaneous triple talaq went without legal validity and was held unconstitutional. This was already illegal because since the 1980s, a number of judgments in High Court held that for talaq to be legally valid, it must hold the following principles: pronouncing for a reasonable cause. These principles are not followed in most cases by the husband, so it's already illegal. This case goes a long way to the case called State of Bombay versus Narasuapa bench in Bombay HC, where it was said that personal law is a source of religion and not state, because personal law is not covering the phrase laws in force. The SC for this showed a positive reaction in Sri Krishna Singh versus Mathura Ahir, 1980. Subsequently, it was reversed in the 1996 judgment of the case Masila Mani Mudaliar and others versus the idol of Swaminatha Swami. The recoil in the 1997 judgment of Ahmedabad Women's Action Group Union of India. It was again